She's not quite showing up yet. Ah, there she is. Welcome. Good morning. Go right ahead, Mr. LaRoe.
May it please the court. Luke LaRoe representing West Villagers for Responsible Government and John Meisel versus the City of Northport in this second-tier certiorari review. And I had the privilege of arguing this back in 2022 in front of two of the esteemed three-member panel today. And I think that just a quote from the order that came from that proceeding, as the case travels up the judicial ladder, review should consistently become narrower. And I think that that's going to be the theme of today's argument.
Right. And before you get totally into this, and I really don't want to throw you off your argument here, we've developed some concern about the authority of the courts to review a municipality's decision whether or not to file a contraction ordinance. And don't propose that you deal with that today because I recognize this is sort of an ambush. So we're good. We'll be issuing an order asking you to submit supplemental briefs on that after the argument. But go right ahead with your planned remarks and we'll deal with that later.
Very good, very good. Obviously, this court is familiar with the procedural background of this case. The petitioners properly submitted a petition for contraction seeking a de-annexation of the applicable property from the City of Northport. And after several months, a hearing was held in April of 2021, and we took up a petition for writ of certiorari after that final order from the city was given, and obtained a very, very thorough and well thought out decision from the original trial court reviewing this particular matter. From our perspective, the insistence of the city not to change any of the evidence, not to allow any modifications, not to open the procedure to new evidence after the grant of the original petition for writ of certiorari and after the equivalent of the affirmance from this court denying the second-tier petition for writ of certiorari. It was our position that basically restricting the introduction of any new evidence or testimony would result in the application of both the law of the case doctrine and res judicata, same parties and exactly the same evidence.
Mr. LaRoe, I appreciate that, you know, where you're coming from on this, and I appreciate how well you briefed this issue. And I guess as I read this, I thought to myself, what really happened in Villagers 1 is that the city did not articulate any findings to support its decision. And that's pretty much what the circuit judge did in Villagers 1, said, you know, your order didn't articulate the basis for your decision. And we basically, granted cert and it went back. And so I have scratched my head and said, I don't see the problem with the city then, based on the same evidence, more thoroughly rendering an order, you know, elucidating their findings. And the Second Circuit judge basically said, okay, you've done enough here. You've at least explained your position. That seemed to be what we expected should happen. So I'm having a hard time understanding the law of the case and the res judicata arguments, because really what the city did and what the subsequent circuit judge did is exactly, I mean, I can't speak for everybody on that first panel, but in my mind, that's what I figured would happen. So, but you have a problem with the way it was done. It sounds like you think they should have had another hearing with more evidence, because no one ever said there was a paucity of evidence in the first hearing. It's just that the order didn't elucidate on the basis on which it came to its conclusion.
Well, I think that in part that's absolutely correct, but the big issue from our perspective is there were some findings, some conclusions of law, findings of fact in that first order that are inescapable. probably the one that's the most notable is that in order to even meet the qualification for annexation, there can't be any enclaves. And I think what the original trial court did in Villagers 1 is that it said that even the city, and in the report that it relied on, conceded that there were enclaves. So that automatically makes the property appropriate for a contraction or a de-annexation. And I don't, there's nothing that can change that. It's in the city's report. The other issue, I think, goes to,
Isn't that an
I'm
issue?
sorry,
Isn't that an issue that should be raised in a plenary appeal?
I don't think so, because that issue was contained in the final order in the original Villagers 1 decision. I don't think that the city made any, they were the ones that conceded that. So from our perspective, that finding, that absolutely inescapable fact renders this property appropriate for contraction, and nothing in the record changed any of that. There was never any introduction of any evidence to in any way equivocate or retreat from the finding that there were enclaves. The other, and obviously, I think one of the most important issues here, and this is where I would respectfully disagree with the fact that the only aspect of the lower court order was just that the findings were not specific enough. I think that the implicit understanding in the original petition was that the city, regardless of whatever findings it articulated, had completely and erroneously come up with their own, excuse me, come up with their own definition. So sorry. Come up with their own definition of feasibility, which the original Villagers 1 decision went into great depth, going back to, the fact that this statute's been around since 1869 and that citizens have the right to review this. And I think that instead of just criticizing the what I'll say is the cryptic nature of the city's findings, the criticism, I think, existed to the city's reasoning and misapplication of the plain language of the statute as it existed then, that it wasn't if something should be done, but if something could be done. And I think that probably the most notable aspect of the Villagers 1 grant of the petition for writ of certiorari is that the trial court judge went into a very in-depth analysis of the legislative construction of that very term. And I think the most notable aspect is that despite what the city was concerned with as far as any kind of transition based on the ability to contract or to de-annex, that Chapter 171 contemplates a mechanism, a solution for all of those things, so that for the city to conclude that it just couldn't.
Let me ask this. Is it your position? Let's assume that you are the circuit judge in Villagers 1 was correct that the city was mistaken in its view of feasibility. Is it your view that if the examination of feasibility, which is required under the statute, results in a determination that contraction would be feasible, is it your contention that the city then must contract?
I think, well, let me frame it this way. I think that, again, looking at the history of this statute, the city would need legitimate reasons that met the definitions and the criteria of the statute. So if it is feasible.
But at the time of this petition, there was no statutory definition of feasibility.
That is correct.
There has been one since.
Yes,
Right.
There has been. And our trial court judge, again, went through all of the proper conclusions of law relative to the interpretation of that term.
Yeah, but coming back, where in the law is there a provision that mandates the city to proceed with a contraction ordinance if it determines that contraction would be feasible?
Well, I think it gets down to the very evidence that's needed to support a quasi-judicial decision. Obviously, the petition was quasi-judicial. Evidence was presented. The original trial court found that that evidence was not competent or substantial enough to support the city's findings, and then went into depth about what has happened. And so from my perspective, I wouldn't use the word mandate, but there would need to be competent, substantial evidence to support the denial that didn't deviate from the observations of the trial court. So for instance, if it is feasible and if it can be done, and if it meets the requirements, as we talked about the enclaves, it never should have been annexed, but if it meets those requirements and then satisfies those other criteria, it would seem like a departure from the essential requirements of the law for the city to deny it. I'm reluctant to use the word mandate.
Well, departure from the essential requirements of law is not, I mean, you know, that's sort of a judicial standard, is it not? I mean, I'm wondering if this is applicable to a city council determining whether to annex, you know, adjust the boundaries of a municipality, which every case I've ever seen says is a legislative power, not a quasi-judicial one.
Well, and let me stress this point. When this litigation began, the statute was largely the same as it was in 1974. After this litigation, the legislature changed it from quasi-judicial to a legislative process.
Well,
obviously,
and again, we're starting to get into what you may well be dealing with in your the supplemental briefs we're going to question. But I can't find any requirement in the statute that was applicable at the time of this case that the city take any evidence.
actually, the statute requires a study of the feasibility to be completed within 6 months.
Correct. It didn't say you have to take evidence. And what the city did, you know, a city could hire a consultant, the city could have staff study this feasibility. I mean, there was nothing in the statute that said you have to take evidence.
But obviously, if you're in a quasi-judicial hearing, in order to establish that you have competent, substantial evidence to support your findings, to me, that presumes that there needs to be some evidence presented. I don't think that you can establish competent, substantial evidence to support any finding without the taking of some evidence in a quasi-judicial proceeding. In fact,
but if the power to annex or contract is legislative, how can you say that the proceeding in which the city council made its determination not to is quasi-judicial?
Because that's what the statute describes the process as being. It was a quasi-judicial hearing.
Okay,
And-
so we
and-
would need to look in the statute to find that, but you're saying that it's there.
Absolutely. And I
Okay.
guess from my perspective, if it wasn't there, why would they need to change the statute to now make it legislative? I mean, if it was already in there, I don't think they would have needed to add that or change that. So that's a huge change, and I think that certainly would support the conclusion that it was a quasi-judicial proceeding. So essentially, from our perspective, using the same evidence, and again, as we argued, required to rely on we can't just ignore the original Villagers 1 decision. And I know that the city has urged that. I think that the second decision, the one before this court today, attempted in every way possible to just ignore every aspect of that decision. But from our perspective, the findings regarding feasibility, certainly the issue as far as the enclaves and all of the other criteria supported the fact that the city basically departed from the essential requirements of the law. And I use that term gracefully because I think it's a good way to describe the city just blew it because they didn't have sufficient evidence to support their decision in denying it. And quite honestly, I think if you look at the record and you also look at the components of the original Villagers 1 decision, every reason that the city came up with was either using the definition of feasibility improperly or was basically viewing the aspect that we can't do this because it's going to be really hard, and ignoring purposely all of those other provisions which Villagers 1 identified, all of the provisions in Chapter 171 that provide a mechanism. Just because it's not easy doesn't mean it's not feasible. And I think that the contemplation, and I think the court said implicitly there are the provisions of Chapter 171 to assist the city and the county in making this transition take place. Maybe it's going to be difficult. There might be some bumps along the way, but there's, I think one of the decisions here in the lower court, I think the commission's decision that there's no deadline, there's not intended to be a deadline. And that was one of the reasons they gave. That was a new reason. Well, there's no deadline for this to get taken care of, this contraction to be completed. That by its very nature, there's no deadline because the other provisions of Chapter 171 provide a city and the county with whatever time is necessary to embrace the dispatch of their responsibilities to take this to the next level and get this job done as the Florida legislature viewed was something that's desired by the people. I would imagine I should retain the rest of my time for rebuttal.
You have about 6 minutes. You have about 6 minutes left, so do with them as you please, Mr.
All right, I'll preserve the rest for rebuttal. Thank you.
Okay, sure. Okay. We'll hear from the city now.
May it please the court, Elizabeth Nyberger for the city of Northport. To start, the statute at issue at the time, before it was amended, provided that if a governing body of a municipality rejects a petition for contraction, it must specifically state the reasons. That served as the primary basis for the order that quashed the commission's original order. The circuit court determined that the 5 reasons that the commission articulated in its order were not specific findings of fact. They constituted conclusory statements or ultimate findings which were not sufficient, which departed from the essential requirements of law under the statute.
And how about Ms. Nyberger, Mr. LaRose's position about the definition of feasibility? Because that was also a big issue on the first case, where the judge, as Mr. LaRose said, went into great detail. What is feasibility? And came to the conclusion that based on that record, they had a different definition, that it should be one versus what was utilized. And in addition to that, there was really no factual basis set forth in their denial of that, of Mr. LaRose's request. So how do you reconcile that with this case now that's on appeal, given that background?
Of course. So the conclusion that the city commission applied incorrect interpretation of feasibility, that was a novel interpretation that the circuit court made. There's no definition in the statute. There's no controlling case law on this issue. So the city commission made 5 reasons that it determined that applying its definition as it interpreted the term, that the contraction was not feasible. The city commission viewed the term to allow for policy type decisions in determining whether or not the contraction is feasible. The circuit court disagreed. The circuit court concluded that the term means no more than a technical decision on whether the contraction is possible, whether it can be done, and excludes any value judgments on whether it should be done.
So what you just touched upon, one of the problems I have with this whole litigation is you talked about the city's position that it could base feasibility in part on policy decisions, which is the essence of a legislative power. But while we're on the topic of the definition of feasibility, I'll note I went back and I looked at the session law that amended Chapter 171 last summer, and it provides a definition of feasibility study. I think it's what feasibility study, Doesn't say anything about evidence, right? It says an analysis conducted by qualified staff or consultants of the economic, market, technical, financial, and management feasibility of the proposed annexation or contraction is applicable, okay? And the reason I read that to you is there's no indication whether that amendment to those definitions is prospective or not. Because unlike that statute, the amendment to 171.051 contraction procedures specifically provides that the amendments made by this act to section 171.051 are intended to be prospective in nature and apply only to petitions filed on or after July 1, 2023. There's no such language regarding the alteration to the definition statute. Would we be within our authority to look at that definition, at least as a suggestion of what it has always meant?
I believe that the statutory amendment applies prospectively. We have briefed this matter before the circuit court and here under the prior law. That would be something that we could brief in the supplemental briefing.
Yeah, because is it, I mean, what I'm saying is it meaningful that when the legislature defined feasibility study, it said nothing about evidence, and it did not say that that definition is prospective?
I think that it can be meaningful in terms of interpreting, you know, what the statute at the time meant, but I would have to brief the issue for you on the prospective or retroactive nature of that, you know, that particular provision. But I think that the city's position is that, you know, the amendment is unnecessary in terms of this case for the court to deny the petition. The circuit court found that 4 of the 5 reasons that the city included in its original order were under the incorrect definition of feasibility. They went to the value judgments, but one of them, the city's finding that the area in question did not meet the annexation criteria of the statute as required in order for the property at issue to be eligible for contraction or not. The only issue with that finding was that it was just deemed to be an ultimate finding, conclusory in nature, that was not supported by specific findings as required by the statute under the court's interpretation of the level of specificity that's required. The court determined on that basis, because of the lack of specific findings on the various annexation criteria, because whether land satisfies the criteria can be accomplished in different ways given the various components of the statute, that the lack of specific findings on those various criteria made it impossible for the court to determine whether competent substantial evidence existed in the record to support the city commission's finding that the area in question met the statutory annexation criteria. The court could not.
And Ms. Nyberg, let me follow up with that, because one of the challenges here is that we now have an amendment since that came up before, you know, since the issuing the opinion. I'm the one that authored that opinion, as you know, for Villagers 1. So the question then becomes, if we assume that that amendment does not apply, I know you said it's prospective, and I know there's some, whatever, let's just assume for the sake of my questioning that that amendment does not apply. So what we have before us is because there've been for lack of a better word, evidentiary, you know, there was evidence taken, a quasi-judicial forum, for lack of a better term, where evidence was garnered, specific findings were entered in terms of why they are denying that request. And then we have the trial court basically coming to the conclusion that in light of the specific findings of facts and in light of the current order that the commission prepared, that it was appropriate for the city to conclude that contraction would not be done. So, and now comes up for us, if we still follow that, it's still quasi-judicial, that it still appear on second tier cert. So and as I've indicated in the previous Villagers one, it's very, very narrow review. All we determine, we don't go behind the reasoning, we just have to determine, was procedural due process provided, was the correct law applied? Limited to that, we don't delve into, was that correct, was that not correct? We don't reweigh the evidence. So it's a long question to the point that I know Mr. Leroux said, okay, res judicata. Does res judicata, are we bound by that first thing, given the fact that no new evidence was garnered, or given the circumstances right now was appropriate for the court to rule that contraction could be denied?
Yes. So, Judge, as to res judicata, so in order to grant second-tier certiorari, the court would need to find that the circuit court violated a clearly established principle of law resulting in miscarriage of justice as it relates to res judicata. The problem with the petitioner's argument is that they have not identified a clearly established principle of law that res judicata attaches to a final appellate decision that vacates, quashes, reverses the lower tribunal's final order. As a, looking away from the minutia of the arguments that the petitioners make, and looking at, the system, our court system, that is not what occurs. It would upend the division, the allocation of jurisdiction between a trial court agency with final order authority and a reviewing court on some form of appellate review. It is also contrary to the doctrine of the law of the case and Florida Supreme Court precedent, saying that when you are dealing with proceedings in the same case, successive appeals in the same case in particular, which would include proceedings on remand, that the law of the case doctrine is the relevant doctrine. Res judicata has no application, and that makes sense if the res judicata effect attached to a final appellate decision that vacates or nullifies the lower tribunal's decision. Be difficult to see how the lower tribunal could take any action at all, because res judicata is an absolute bar. So res judicata clearly does not apply, and even more to the standard review, there's no principle of law clearly established that the appellate court's final decision reversing or vacating a lower tribunal's decision has res judicata effect on remand proceedings below. Res judicata has been around for a long time. If that were clearly established principle of law, petitioners would be able to cite a single case standing for that proposition, and they do not. Turning to the law of the case.
Ms. Nyberg, can I shift gears on you?
Yes.
Because I think that we've kind of focused on the preclusive effect of this. I know you're going to get an opportunity to supplementally brief the issue about whether or not the proceeding before the city was quasi-legislative or quasi-judicial. But I am curious about what your preliminary thoughts on that are. Could you tell me?
The preliminary thoughts were that at the time that the original hearing was held as a quasi-judicial hearing, there was no clear legal authority saying whether the proceeding to determine whether or not to reject or move forward with a petition for a contraction ordinance is quasi-judicial or legislative in nature. There is As the court noted, authority clearly saying that annexation is legislative in nature, but this particular proceeding on a petition for contraction ordinance, I don't believe that it was clear, and I believe that, and I personally was not counsel at that time, but I believe that the understanding was that in abundance of caution to follow the city's quasi-judicial procedures was the appropriate course, and so it was held as an evidentiary quasi-judicial hearing.
Okay, so let me
Mhm.
pose a suggestion to you, though. The city, perhaps out of a caution, an abundance of caution, conducted this as if it were a quasi-judicial decision. And that's the procedure it used. But that in itself doesn't make it a quasi-judicial decision, does it? If they're exercising a legislative power.
I would agree that it goes to the jurisdiction on certiorari, and if the court were to determine that it is not quasi-judicial in nature, then that's a determination that could be made as a matter of subject matter jurisdiction.
Because when I went back and I looked at the Villagers 1, and at the time the order in that case, which has been furnished to us by both sides, I guess, in the appendices, just said, hey, the city agrees or acknowledges that there is common law certiorari jurisdiction to review this. Cites a case that doesn't have anything to do with annexation or contraction. The case that when the city made that acknowledgement in its response to the petition to that circuit court, it cited one case, which was a circuit court decision out of St. Lucie County, Vonkix, I guess you would call it, Vonks. And so there was no DCA reference, there was no Supreme Court, I mean, that was it. And that case never went anywhere. It didn't go up. So it's never been reviewed. So is that case is the sole basis for the city's acknowledgement that there was certiorari jurisdiction, correct? I know we're hitting you with something you did not see coming today, but
I believe that was the case that was relied on at the time. The analysis of there are general, cases that assess whether local government action is quasi-judicial, legislative, or executive in nature, and there are various tests. But I believe that the circuit court decision was cited because that was the only one that had particular.
The only one. And so in the 50 years that this chapter has existed, that's the only one. I
believe that there's another circuit court decision.
Another circuit court decision involving contraction or annexation.
Contraction, and there's no district court of appeal or Supreme Court decision.
So, Ms. Nyberger, isn't it also true, though, that in proceedings before municipal governments, the proceeding can be both quasi-judicial and quasi-legislative? In other words, it doesn't necessarily have to be exclusively one or the other. For example, in this situation, the promulgation of the ordinance, if it became appropriate, would be a quasi-legislative function, but perhaps the hearing, the fact-finding hearing that preceded it could be quasi-judicial. Isn't that also true? In other words, the hearings don't need to be exclusively one or the other. They can be a hybrid.
Possibly. I have to say that I'm not able to speak to whether I have any opinion on this.
I totally realize it's an unfair question
here.
because it wasn't briefed, but okay. Well, I'm hoping maybe the briefs will address those kind of issues. And I think that's why we're asking these questions, to give you some idea about what we're going to be looking for.
Very good. So the next issue to address is the petitioners argue that the circuit court in its initial quashal order made a preclusive legal conclusion that the city did not have competent substantial evidence in the record to support findings on the annexation criteria. Because of that explicit finding in the circuit court's order that the court was unable to make that determination, the city commission on remand following the certiorari proceeding was well within the ordinary jurisdiction of a finder of fact on remand to look at the evidence that existed in the record and supply those missing findings of fact to meet the level of specificity that was required by the circuit court's order and the statute. That's the ordinary course when a trial court's agency's order is determined to lack statutory required specific findings to on remand allow that to occur. So there's nothing irregular about what the city commission did here. The evidence existed in the record. The city commission merely made more specific findings on the criteria of annexation. The circuit court's quashal order did discuss the various components of the annexation criteria statute. I just would like to just briefly address the one component that Mr. Leroux mentioned, which is the petitioners take the position that the circuit court in the quash order made a conclusion of law that the city regarding the standard, the requirement of relating to enclaves as part of that annexation criteria. I would just like to emphasize here that the circuit court determined that the lack of specific findings on the annexation criteria precluded any review of unstated findings for competent substantial evidence, and so it had no findings to review. The circuit court did go on to comment on the evidence in the record and what the court believed that showed, which amounted to just mere commentary. Dicta is not binding as law of the case after the circuit court specifically stated that it could not make those determinations. Any gratuitous comments? Yes.
I'd let you exceed your time because we helped you consume.
Absolutely. So with that, ask the court to deny the petition. Thank you, judges.
Thank you.
All right.
Mr. Leroux.
And I thought this was going to be more simple than it became, but here's where we actually based our argument, is that I think that the city's procedures and even in their agenda, they identified this as quasi-judicial. And I think that if you look at the statute, it presumes not so much a blend of quasi-judicial and quasi-legislative, but I think it directs that the decision on feasibility be conducted in a quasi-judicial fashion, and then it morphs into a legislative function. For instance, the referendum or deciding to place it on a referendum, things of that nature, which I think are certainly legislative in character. But from our perspective, in order to allow the city to make a valid decision and to give citizens the right to argue in favor of their petition and do what they think is necessary to try to enjoy the rights given to them under this statute, it certainly, from our perspective, requires the presentation of evidence.
Yeah,
and
Mr. Leroux, the current definition of feasibility study says nothing about evidence. In fact, it says analysis by qualified staff or consultants. And the prior term was not defined, but nothing about it suggests there had to be evidence.
I think that's true now, but I don't think it was true then. And it really suggests
you don't have an opportunity, obviously, to point out in the statute where it requires evidence. I get it, but
Well, certainly from the procedures below, evidence certainly took on a very important character. And obviously it was the evidence that was looked at. But the other argument I want to make is I think that in order to approach this from a perspective of not rendering everything done before the second decision came out meaningless, I think there needs to be some effort to compartmentalize the original Villagers 1. And I would respectfully submit that the finding that the original findings of fact were too cryptic, that they really didn't get into any specifics, was only one component of that order. And quite honestly, I think that the issue as far as the legislative construction of the term feasible and the findings as far as the enclave. So from our perspective, there are certain aspects of that decision that are inescapable. And I think that, and I'll just quote this, and this is important from our perspective, that the city's concession that the area could contain enclaves and pockets undermine any finding of reasonable compactness to the extent the commission finds that such enclaves and pockets are permissible. Such a conclusion is contrary to the plain language of the statutes and departure from the essential requirements of law. So I don't know how that element, and candidly, in the second round, the city said, you know, we're not going to pay any attention to that. That's huge. And I don't think that the city has the ability.
If there were enclaves here, I mean, it's my understanding, it's not, hasn't been directly pertinent to the, but this area that is the subject of the contraction petition was previously annexed, correct?
It was, and
did that annexation create the enclaves that they're attempting to correct with the contraction from your perspective?
the enclaves existed in the area that was annexed, which meant it should not have been annexed, because I think the way.
So did your side file a deck action or lawsuit about that at the time?
No, this went back many, many years.
Well, I'm do it many, many years ago.
We obviously did not, because I think we lay out the procedural progression of this matter. This was quite some time ago, but I don't know that the passage of time would render the inappropriateness of the original annexation appropriate because of the geographical characteristics. And obviously and I feel like I'm interrupting you. I'm sorry.
You're muted. Judge Northcutt, you're muted.
Not me. You're not interrupting me. I do have one more clarification question before you go, but go ahead, finish your thought.
No, but I mean, from our perspective, that, you know, if it should never have been annexed, that certainly suggests that it's appropriate for contraction. And then it gets us into that point where it can't just be left to the absolute discretion of the city. And you know, if you look at the theme of the second decision before this court now, the theme is that the city can come up with just about any reason it wants. It doesn't have to look at feasible. And I think that completely abandons the framework that's provided by the statutes to give citizens the right to seek that contraction. It's just it's an uncomfortable determination that the city has almost unlimited discretion to decide whatever they want. Now, obviously, that might be different in a quasi-judicial context as opposed to a legislative context, but there still has to be.
It's arguable, is it not, that, you know, this could be, you know, a legislative power, and the statute authorizes the citizens to petition the commission to consider it and do a feasibility study.
In all due respect,
otherwise they would have no obligation to do that, correct?
I think it embraces the rights of the citizens to seek a contraction by requiring the city to evaluate the feasibility. Now, the whole concept of study is a creature of the new amendment. It was never identified as a study before. It was simply the concept of feasibility.
Or not. All it says was a feasibility study, correct? And here's my question, and your time is up, so I'll ask it right now. And it's my understanding that in the first go-round, Villagers 1, when the commission considered this, you know, petition, it engaged consultants on the feasibility question. Did it not?
The answer to that is it engaged consultants to conduct a feasibility study, which Villagers One said that's not what the job was, candidly.
Right, but they did. That's what they did.
And they hired
and
experts that
under
made,
Under the
I'm-
current statute suggests, directs that they do just that sort of thing. Hire experts to conduct a feasibility study or qualified staff.
the current statute does provide for a feasibility study or staff reports, yes.
All right. So your time's up.
All
Thank you
right,
both.
thank you for the privilege. Thank you very much. I enjoyed
We'll be
this.
back in touch.
Excellent. Thank you and have a good day, everyone. Thank you.
Interesting case.
Very.
Yeah, it saved me from interesting cases.
And really well argued by both sides. Thank you both.
Yeah, in order
Thank
to
you all
leave
very
our